So welcome to today's webinar on child protection reform amendments in Queensland. So I'm Carly Hanson, I'm from Community Legal Centres Queensland, and before we get started I'd like to acknowledge the traditional owners of the land on which we're holding this webinar today. In Brisbane they are the Turrbal and the Yagara people. I wish to pay my respects to elders past, present and emerging, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and across the country, I'd also like to pay my respects to the traditional owners of the land throughout Australia and extend a really warm welcome to any First Australians who are listening in today. So today we've got presenters from the Department of Child Safety, Youth and Women, Debbie Jensen and Karen Ruska. So they'll be talking to us, as mentioned previously, about some of the child protection amendments that came in October 2017 and those changes that are being rolled out throughout 2018. So some of the aims of the legislation are around the safe care and connection of Aboriginal and Torres Strait Islander children with their families, communities and cultures, permanency and stability for children now and throughout their lives, including support when they leave care, a contemporary information sharing framework focused on children's safety and well-being, as well as other changes that support the Supporting Families Changing Futures reforms. So the Queensland Government is taking a staged approach to the commencement of these amendments, and today Debbie and Karen will talk to us about the intent of the legislative amendments, what the amendments mean for child protection practice in Queensland, and also how it may impact the court and legal system. So we're recording today's webinar. As per usual, we'll put that one up on our website hopefully this afternoon. We've also sent out the PowerPoints this morning to everyone who had registered, and I've uploaded those to the handout section of the GoToWebinar control panel if you'd like to download those. We'll also have questions at the end of the presentation, but if you do want to type in any questions as you think of them as we go through today, please do so just by typing those into the questions box on your GoToWebinar control panel. So I think that's everything from me. You'll hear back from me at the end of the presentation to take those questions, but for now I might hand over to our presenters, Debbie and Karen. Thank you very much.
Thanks, Carly. It's Deb Jensen. I'm going to start the presentation and then I'll hand over to Karen. Thank you, everybody, for coming to the webinar today. As Carly mentioned, the Queensland Government has been focusing on building a new child protection and family support system through the Supporting Families Changing Futures reform program. This legislation is actually an opportunity to improve our legislation and build a contemporary legislation that helps us reflect the role of parents, families, communities and government and non-government and the private sector in supporting Queensland children and families now and into the future. You may be aware that the Parliament passed this legislation in October last year and it was assented to in November 2017. What that means is that it would automatically go live on the 11th of November 2018 this year. You may be aware, as Carly mentioned, that we've taken a staged approach to the implementation of these legislative reforms. And we had some legislation go live on the 29th of January this year, and they were predominantly a few information sharing provisions. And then we had some further amendments go live on the 23rd of July this year, which were predominantly around some clarifications related to temporary custody orders, some changes to immunisation, some slight changes to how we undertake intervention with parental agreement, an improvement to how we can undertake research and data, and an improvement on how we actually share information, particularly with Queensland Police, and then also an opportunity to improve how the publishing of information regarding child witnesses is released to ensure that it remains confidential. The final stage of the legislative amendments is a plan to take commence pending Executive Council approval in late October this year. It's going to Executive Council on the 11th of October this year, so after that date we'll be able to formally confirm what the actual date of the commencement is. The Amendment Act has a range of intent, and Cully did talk to some of these briefly, and Karen will go through some of these in a little bit more detail in a sec. But there are four main elements to the legislative changes, and they primarily relate to promoting positive long-term outcomes for children in the child protection system through timely decision-making and decisive action towards either reunification with family or alternative long-term care. The critical words and the shift in this particular one is particularly the timely decision-making and decisive action towards either reunification. So Karen will talk to the elements of permanency in a sec. The next one is around promoting the safe care and connection of Aboriginal and Torres Strait Islander children with their families, communities and culture. This one underpins every activity and function that is administered under the Child Protection Act. So whether it's this department or whether it's funded services or people like yourselves working in the legal system, we have a responsibility to give effect to the to self-determination and to the 5 elements of the child placement principle. One of the other elements is related to providing contemporary information for the child protection and family support system, which focuses on children's safety and well-being. This one allows us to be a little bit more agile and flexible around who we can share what information with in relation to the best interests of the child. The final one is of course supporting the implementation of other key reforms under the Supporting Family Changing Futures reform. That in particular picks up on the Our Way strategy and has identified some other legislative things that we will need to address. So things under the Royal Commission, some of the implementation activities provide a good foundation for ensuring that we're meeting the Royal Commission requirements as well. One of the main changes that sort of underpins and needs to be considered as a part of anything that any activity or function, anyone who's administering an activity or function under the Act, is that the paramount principle has been amended. So originally it was for the safety, wellbeing and best interest of a child. What has been added is that it's the safety, wellbeing and best interest of a child, both through childhood and for the rest of the child's life. So when you think about that and you think about particularly promoting positive long-term outcomes for children in the child protection system through timely decision-making and decisive action and safe care and connection, we need to be thinking about it not just in the moment when the child comes into the system, but what any decision we make from that beginning point means for the child and the rest of their life.
Deb, sorry to interrupt. Oh, sorry, Deb. We just are still on the first slide, so I just wanted to flag with you to remember to move through those PowerPoint slides. Thank you.
We have been moving through.
Okay, so I can only see the first slide, so I'm not sure if there's an issue with the PowerPoint for everyone who's watching today, but we may need to sort of have a look at how that's working, perhaps.
Is there something I can do differently? Because we have been flicking through it.
It might be because you've got the dual screen, I'm not sure. So we are just sitting on the first slide now.
I've unplugged the other screen. I don't know what else to do.
That's all right, it might just be me. Perhaps if anyone else is having an issue with the PowerPoint slides, just open the hard copy or the electronic copy that's been uploaded into GoToWebinar, or move along with your hard copy slides.
Okay, all right.
Will you just let us know, Carly, if there's still an issue, if there's something else we can do? It's Karen here now. I'm going to do the next bit of the presentation, so I'll just tell everyone what slide we're on to, what number, as we're going through, if that helps.
Thank you. Sounds good.
All right. So everyone, my name's Karen Rusker. I'm a Quandamooka person, so my family's from North Stradbroke Island and my community's there. I'm on secondment at the moment from Caxton Legal Centre into the Office of Child and Family Official Solicitor within Child Safety, looking at implementing the reforms into some of the business processes and resources of OCFOS, particularly around safe care and connection. So these today we're really going to focus on the parts of the reform around safe care and connection and permanency to give you an overview of what that might look like in practice, what the reforms are. So just on slide 4 now, looking at the overview there of safe care and connection and the relevant sections of the Act, which I'll go through in a minute. So on to slide 5. Safe care and connection is really an intentional practice approach that recognises the right of Aboriginal and Torres Strait Islander people's self-determination, considers the long-term impacts of decisions on a child's identity, connection with family and community, and includes all 5 elements of the child placement principle. So the legislative changes are really, the first to consider is section 5C. This is on slide 6 now. Section 5C introduces new principles that underpin the administration of the Act. So the new additional principles about Aboriginal and Torres Strait Islander children and families is firstly recognising the right of Aboriginal and Torres Strait Islander peoples to self-determination. And again, as I said, considering the long-term effect of decisions on their identity and connection to family and community, and includes all 5 elements of the Aboriginal and Torres Strait Islander child placement principle. I'll go through in detail what those elements are now. So we used to have, most people knew the child placement principle as the section 83 sort of hierarchy of placement, about, you know, firstly looking at placing children within their family or within their community, within another Aboriginal or Torres Strait Islander family, or lastly outside of that. But the new research and information that's been coming from the Secretariat of National Aboriginal and Islander Childcare and the Queensland Child Protection Peak for Aboriginal and Torres Strait Islander families is that the child placement principle is much more than just that one element, and it's really a much more expanded principle that's now been embedded into the legislation. So I'll talk through what that looks like and what it might mean in practice shortly. The other legislative changes to be aware of is section 51B, which says a case plan for Aboriginal and Torres Strait Islander children must include details about how the child will maintain their connections with their family, community and culture, and recognise the importance of that. Also in 51BA, there's provisions for concurrent planning to be required in case plans, which is your goals for reunification and permanency. So whether it's looking at reunification goals, but also if that can't occur, then what's envisaged to occur. And I'll talk about the concurrent planning more around permanency as well. So section 83 has also just been amended to strengthen that requirement to firstly explore options for placing children within families. So the underlying principle of self-determination really has been a push from community for a long time to have it explicitly acknowledge that Aboriginal and Torres Strait Islander children and families do have expert knowledge about their own lives and will provide the primary source of cultural advice. And so the principle now requires that self-determination is applied throughout all decisions. So what that means in practice is that, and we're shifting to a position where Aboriginal and Torres Strait Islander families actually have input in decisions made about them. That's what the intent of these new provisions coming into force means. And that it's families themselves who will be able to give advice to the department about their own culture and their own lives and their own strengths, the strengths and weaknesses within their own families. Now on to slide 8. So the placement principles. So the new section 6AA in brackets 2 subsection 2 requires that when making a decision, a significant decision about an Aboriginal or Torres Strait Islander child, the Chief Executive, the Litigation Director or an authorised officer must have regard to the child placement principles in relation to the child. So we've got the principles embedded into section 5C, but also this provision around any significant decision around a child, that then the child placement principles must be considered. So the child placement principles are now set out into 5 principles. Prevention, firstly, so that a child has a right to be brought up within the child's own family and community. So what that will look like, what that means in practice would be steps being taken to, in the early stages, to keep children safe within families and work with families to say how, what needs to be put in place so that can occur. And that might be referrals to some of the early intervention services and that sort of thing. Also, really working with families early to say, who is this family? Where are they from? Where are you from? Who are the important people in your family? Who can help support to make this happen, to keep children safe within the family as much as possible. The next principle is around partnership. So it's about the principle that Aboriginal and Torres Strait Islander persons have the right to participate in significant decisions under the Child Protection Act. And in practice, that means the department working closely with families throughout all decisions under the Child Protection Act, and also working in partnership with community organisations that can support those families and children. Placement is the principle that if the child's to be placed in care, they have a right to be placed with a member of the child's family group, and that also refers then to the section 83 placement hierarchy, which is in the Act as well, around how those placements should occur. On to slide 9 now. The 4th principle is about participation, which is that a child and the child's parents and family members have a right to participate and be enabled to participate in any decision-making processes for around a significant decision about a child. So again, it's about really comes back to people's rights to self-determination and to being involved in those decision-making processes. And that might be then, there's a new principle, a new provision, which I'll go to next, which is about an independent person being enabled to facilitate a family's participation as well. So the provisions around how the department will support families to participate in decision making. And the 5th principle is around connection, so that the child has a right to maintain their connection with the family, community, culture, traditions and language. So particularly so when the person's in the care of a person who's not an Aboriginal or Torres Strait Islander person. So this really focuses on what the community's been concerned about, which came right back from the Bringing Them Home report all the way through, about the importance of connection so that children can maintain their identity and their cultural identity as well. So their sense of really, who they are, where they belong, where they fit, it's really important that those connections are maintained. So in terms of I guess for with your clients, if you have an Aboriginal Torres Strait Islander person come in for advice in a child protection matter, once these reforms come into place, that's something to be aware of. And if they've got sort of academic material from the department, is looking for whether those elements of the child placement principle have been complied with, whether they've been considered in decision making. That should be apparent in the affidavit material reflecting the practice. So in terms of increasing participation, then what we see is a big change, which is a shift from recognised entities. For any of you who've worked with Aboriginal and Torres Strait Islander families in child protection, you know that we currently have recognised entities that work with the department and work with families. There's a shift now from recognised entities and the introduction of this new concept of an independent Aboriginal or Torres Strait Islander entity. which the department in practice will be referring to as an independent person. So there'll no longer be an independent entity providing cultural advice to the department, a recognised entity providing cultural advice to the department around decisions. The intent is that families themselves have that knowledge, and we need to encourage and enable families' participation so that information can be provided directly from the families. At the same time as these reforms roll out, there's also going to be the commencement of the Family Participation Program, which is to enable families' participation in child protection matters. So the Family Participation Program will be funded by the department, and its role is to provide independent facilitation of Aboriginal and Torres Strait Islander family-led decision-making processes. And that's a process where parents, children and families work together with the department or work together to solve, to sort of lead decision making and work towards solving problems in a culturally safe space. So that's why it'll be an independent body leading that decision making. And that can occur, it's envisaged that that can occur at any stage in the child protection continuum. So it might be early on, but a referral to a family participation program, so that some of those early questions about, you know, what needs to be put in place, what do you need to keep the family safe and to keep the children safe and keep them at home, those sorts of discussions can be had in that family-led decision-making space early on. The Family Participation Program will work alongside the current Aboriginal and Torres Strait Islander Family Wellbeing Services, which will continue their role in providing support services to families. So just moving on to this new concept of independent person, which is coming into force. So Section 6 is the provision that outlines who can be an independent Aboriginal and Torres Strait Islander entity for the child. Section 6AA requires the Chief Executive, authorised officers and the litigation director to arrange for an independent person to facilitate the participation of the child and family in relation to all significant decisions. And then Schedule 3 of the Act, that includes a definition of significant decisions. So they're the main provisions around independent person, which we'll talk about now. So the purpose of the independent person, so it's has a different role to the recognised entity. So they're not replacing what was the recognised entity. It's a different role. It's about someone independent from the person, from the department, that the families nominate themselves, that help the families to participate in the proceedings or in the processes. So they're not there to give their own views or give the department any kind of assessment or recommendation. They're there to support families. So it's akin almost to a support person role. So the child and the family can choose an independent person to facilitate their participation. And each time there's a significant decision, then the department needs to be asking the family again if they have an independent person they'd like to nominate and discuss, you know, who they want. In practice, then you might have mum having a different, nominating someone, dad nominating someone else, particularly if they're from different cultural groups. And if the child's old enough, the child might also want to nominate an independent person to support them as well and support their participation. So with your clients, that's one of the first things I'd be checking is whether that's been offered to them, whether the department has had those conversations with the child and their parents about an independent person being involved in the process. So the role is really to support the child and their family. So I'm on slide 13 for those who can't see it on the screen. To support the child and their family feel stronger and supported to say everything that they wish to say. And the independent person can provide some contextual cultural information about, you know, things that might be impacting on a parent, things the department's not aware about that's actually a cultural factor that's impacting what's happening with the family or how things are being viewed by the department, but it might actually be a misunderstanding of cultural factors. So the next slide, I think I'll move to. The Act provides that the independent person must be arranged for significant decisions. So significant decisions are now defined, will now be defined in the legislation as a decision that's likely to have a significant impact on the child's life. So sorry, I seem to have a different slide even in front of me. Here we go. So the department, you know, thought about what those significant decisions would be, and it would be any significant decision starting from, you know, the investigation and assessment stage through to the ongoing intervention stage. So it might be decisions about how to keep a child safe, so around safety planning. Onto the next slide might be decisions about whether a child is in need of protection. It's about decisions about what type of ongoing intervention will be undertaken with the family, a decision to refer a matter to the DCPL for a child protection order, and a decision about where or with whom a child will live. So that's provided for in section 83(2) as well. There's also a provision in the Act for the independent person to be involved in case planning meetings. So it can be at all stages of the child protection continuum where an independent person can be offered to a family, and the department is to enable their participation. So the department has developed a range of brochures and fact sheets around independent person and video as well, so that because the department has to, you know, the obligation on the Act of the department arranges it. So the families nominate, but the department has to be making it clear to families that the opportunity exists for them to have an independent person and to explain what the role is. So there are brochures that have now been developed that will be available on the department's website, and department CSOs would be giving those to families to explain what the independent person is and to help families to make an informed decision. I should say families don't have to have an independent person. It's completely up to them. And if families don't want to have an independent person involved for a particular decision or for any of their decision making, the department still has an obligation under the 5 principles and under the principle around self-determination to be ensuring that families still participate in decision making at every stage and still have meaningful participation. The next important provision in the Act is around court. So the only real mention of the independent person in court proceedings is in section 6AB, and the court must have regard to the child placement principles and any Aboriginal tradition and island custom relating to the child. That's going to be in the new provisions in 6AB. But in terms of the independent entity, then the only mention is that to inform itself about Aboriginal tradition and island custom, the court may have regard to the views of the independent person, the child, or a member of the child's family. So if the family wanted an independent person to come to court with them, and if the independent person was happy to do so, they're there still just to facilitate the family's participation. They're not there to give their own views to the court about the matter before the court. They're there to support the family and support the family to put their own information to the court. The only time that the court will may seek their views is around that Aboriginal tradition and island custom relating to the child. So that's section 6AB. I should also mention, and I forgot to say so before, that if a family chooses, the family can, if they're already working, say, with a family participation program or with another service, the family can nominate someone from one of those services to be their independent person as well. That's also provided for in the Act. So it may be that the family doesn't have anyone within their own family that they want to come along because of, you know, maybe they don't want people to know, but they could opt to have someone from one of the services that they're working with if they chose to do so. So in terms of exceptions to the having an independent person, in 6AA subsection 3, which is, we're on to slide 17 now. The first thing to remember is if the child or the child's family doesn't consent, if they don't want one, then they don't have to have an independent person. There's nothing compelling them to have an independent person, and the department doesn't get to choose one for them. If the families don't want one, then they don't have to have an independent person. There's still a requirement that every significant decision by the department will need to be asking the family again about whether they want an independent person for that particular decision. The other exceptions are that if it's not practicable because the person's not available or urgent actions required to protect the child, or if arranging it's likely to have an adverse effect on the safety or psychological or emotional well-being of the child or any other person, or if it's otherwise not in the child's best interest. So there are some exceptions there that may come into effect. So then the next slide is slide 18, and the next couple of slides will run through then who can be an independent person and goes to questions around suitability. So this is section 6 of the Act in terms of who can be an independent person. So section 6.2, section 6.2. So a person who can be an independent person is a group or individual. So it's an individual who's an Aboriginal and Torres Strait Islander person, or another entity whose members include individuals who are Aboriginal or Torres Strait Islander persons. So that's where it might be a service provider that's working with the family, and the family or child or family are comfortable nominating someone from that service to be their independent person. And the chief executive is satisfied the person that the entity provides services to Aboriginal or Torres Strait Islander persons, or is representative of the child's community or language group, or satisfies the requirements in subsection 2. So this is section 6 of the Act that we're still in. And then subsection 2 is if the person is of significance to the child and family, is a suitable person for association on a daily basis with the child, has appropriate authority to speak about Aboriginal and Torres Strait Islander culture in relation to the child, and not an officer of the or employee of the department. And then the third subsection in that section is that the chief executive has to be satisfied that they're a suitable person to be an independent entity for the child. So with those provisions in the Act, then the department does have a role in determining suitability. The chief executive is required to be satisfied the person's suitable. In terms of how the department's approaching this, it's not blue cards or criminal history checks or any of that sort of heavier assessment. It's a really more a light touch approach because, you know, in the spirit of the provisions around the principles around self-determination and people nominating their own independent person, the department will simply take information from the family about the nominated person, and then consider whether there's any conflict of interest, or the first they consider if it is someone who can be an independent person under the first 2 subsections. But then they'll consider the information provided just by the family generally, and then look at the department's own records concerning the nominated person. And the only way that that would be relevant is if it was anything of immediate concern that indicated an immediate risk to the child. So also any information gathered by the department from their own records about the nominated person, obviously because of confidentiality, wouldn't be shared with the child or family, except to say that if the person's not suitable. But no, the reasons why, if it was something in the person's child protection history, it wouldn't be disclosed to them. So. Examples of a conflict of interest may be something like if the person nominated as an independent person made an application under Section 113 to be a party to the proceedings, then that may give rise to a conflict of interest depending on the circumstances. So that may mean that they would no longer be suitable. So it's really going to depend on individual cases around that. But as I said, the department's approach is to take a really light touch with the suitability, and there's talk about so that there aren't any issues arising if someone's nominated a particular person from their family to be their independent person, and come the day of the meeting, that person's not available and they want someone else to come along. They could either come along just as a support person, which is fine anyway, or they could be assessed as an independent person for that person. But the department is talking about perhaps asking families early on if they've got a number of different people that they'd like to nominate as their independent person, so they can all be considered early on, and then there are no more questions. There should be no more issues around suitability on a particular day of a person. So something else to remember around independent persons, so to bear in mind, is that they don't have to attend. They're not compelled to attend meetings or court, but the family can certainly ask them to attend, and if they want to, then they can, but there's nothing compelling them, and they're not there to replace the role of the recognised entity. They're there to facilitate the family's participation. Another significant change that I wanted to talk to you about today is around the permanency provisions that are coming into force. So the slide 22 sets out the key provisions in the legislation around permanency that you can have a look at, but we'll run through the main elements of those now. So if I can just, go back. So in Section 51B and 75, there's the transition to independence. So I'll just for your information, give you some brief overview of what that is. So Section 51B now requires that case plans must include actions for helping children transition to independence if the child's 15 years or more and doesn't have a long-term guardian. So there needs to be transition to independence in the case plans. And Section 75 now requires that the department must ensure help is available until the child is 25. So that's a shift. And help includes things like help to access entitlements, to access education and training, help to obtain employment, help to obtain legal advice, help to access health and community services, and support in maintaining or establishing relationships with family and carers, and help in accessing information about the person's time in care. So that now goes until the child is 25, that assistance that has to be provided by the department. That's something to keep in mind if you have people who are coming out of care or have children, clients whose children are in care and getting to that age. So something really important for all of you with your clients in the child protection system is this new provision in Section 62, or the amended Section 62, which introduces a restriction on consecutive short-term orders beyond 2 years, with some exceptions. So this really came out of the Carmody inquiry and the concerns around consecutive short-term orders and the concerns around the instability that creates for carers and children, but also for families. And families would complain that they're getting a 2-year order, nothing much is happening, and then there's another 2-year order and still nothing much is happening. And so there's this new restriction on consecutive short-term orders beyond 2 years. The exception is if another short-term order is in the best interest of the child and the court considers reunification is reasonably achievable in the longer term. So for your clients who already may have a short-term order, if they're wanting another, if the department's seeking a long-term order after that and your client is wanting another short-term order, then we need to have information about that reunification is reasonably achievable in the next short-term order. So it really puts pressure on the department and families to take steps to achieve reunification within that 2-year time frame. And so it would require very clear case planning goals. In the case plans, you'd want 6-monthly goals that and that are very clear, so that families and the department can work towards those and work towards reunification. So clients really need to be aware of this new restriction very early on. If you're seeing clients who are just having contact with the department and then there's a consideration of applying for a short-term order, the clients need to know that this is possibly the only short-term order unless you can satisfy those exceptions. Section 51B(1)(a) then requires concurrent case planning in case plans. So it's a requirement. And so you clients with a case plan will then now be seeing a case plan that has information about reunification, but also talks about if this reunification doesn't occur, what's the alternative? So it will be right there in black and white, which understandably can be off-putting for clients to see that, and the department will have to talk through with clients about why that's in there and what it means. The other provision, a new provision, is this new type of order called a permanent care order. That's in section 59(7)(a). So you've got your current short-term and long-term orders, but now this is a new type of order called a permanent care order. And this also came out of the recommendations in the Carmody inquiry. The major practical difference between the long-term guardianship order and the permanent care order that you'll need to be aware of is that only the DCPL can apply to revoke the permanent care order. And section 65(a) sets out the grounds to revoke. So parents don't have the right to apply to revoke the order. It's only the DCPL. And I gather the intent of that and of Carmody's recommendations around that was to ensure some stability. Families were still, some of the feedback from former children in care and carers was that the possibility of revocations and going back to court caused some instability for children in care. So in terms of a permanent care order, if there's one in place, it really means that the department in some ways steps out and that the permanent care guardian is then the guardian for the child and makes all those decisions for the child. If there's an issue with the permanent care order, the only option really then available to parents is to make a complaint to the chief executive, so to make a complaint to the department. And the new section 80B to 80E deals with that complaints process. So then once that decision if a family makes a complaint, the department makes a decision on that complaint, then that can become a reviewable decision for the purposes of QCAP. But so that's how that will work with permanent care orders. As I said, no right to apply for revocation by parents. There are you can imagine there might be a circumstance where a permanent care order might be appropriate, and that would be situations where the child's in a long-term stable kinship placement and the carers and the child and the family are really happy to move away from the involvement of the department and have a permanent care order in place. I can imagine that may work for some families, but apart from that, I don't know that I can imagine many permanent care orders being applied for, to be honest, but we'll have to wait and see what happens and how the department approaches it. So under a permanent care order, the carers are still obliged to keep the department informed about where the child's living, that's in section 69(3) of the Act, and to notify the department immediately if the child leaves their care, so that's section 80A. And in those circumstances, then the department may decide to apply to revoke the order and start a new assessment of a carer for the child. So sorry, on that slide 24, sorry Debbie, I didn't even talk about all the content of that, but section 59.7a sets out the grounds for a permanent care order, so what the court has to be satisfied about, and that's set out on slide 24. One of the requirements is that the child has to have been in the care of the proposed guardian for 12 months immediately before the making of the application, unless the Act says unless there's an exceptional circumstance that justifies the making of the order. There are also some additional matters for Aboriginal and Torres Strait Islander children providing for section 59A in relation to permanent care orders. So the new section 59A requires the court to have proper regard, and we don't know what that means yet, but proper regard to Aboriginal tradition and island custom in relation to the child and to those child placement principles. There's also that provision for the court to inform itself about Aboriginal traditional island custom. They may have regard to the views of the independent person, the child, or a member of the child's family. So they're the additional matters in relation to permanent care orders. Another additional matter is that the court has to be satisfied that the case plan includes details about how the child's connection with his or her culture and community or language group will be developed or maintained. And that the decision, or if the child's, if it's appropriate, that the decision's been made in consultation with the child. So they're the other additional considerations for Aboriginal and Torres Strait Islander children. So if you have a client come to you where the department's applying for a permanent care order, then you'd have to look at whether all those grounds have been satisfied, firstly. There was one other thing I was going to say, which has just slipped my mind. I have lost it. I can see we're running close to the end of time, so we weren't going to go into any detail on the information sharing changes, but you should know that the department has developed some new information sharing guidelines that will come into effect with these new changes, and you can have a look at those sections yourself around information sharing and the intent of that on the slide 27. So that's just to enable, I guess, better information sharing. One thing about the independent person, sorry, that has come up in questions for other presentations is whether they're bound by any confidentiality requirements under the Act, and the answer to that is yes. The independent person under the Act is deemed to be a service provider just for that purpose, so they're bound by confidentiality requirements, and that will be communicated to the nominated independent person in the department's conversations and brochures around the role of the independent person. And the one thing I've got to say about permanent guardian care guardians is the department will have an assessment process to assess whether a person is suitable to be a permanent care guardian if they're applying for a permanent care order. So there'll be a comprehensive assessment that the department will be applying to see if that person's suitable. And that's being developed currently. So that's really all the information about the main summary of the reforms around safe care and connection and around permanency. There is information on the child protection, on the child safety website, and also you're free to call the implementation team if there are any particular questions and you haven't been able to find the answer to that in any of the material that's available. So yes, all of this will be rolling out at the end of October, and then we get to see how it looks in practice. So.
Thanks, Karen. That was really good and very detailed. So we might go to questions now. A couple have already come through, but for those who have a burning question you'd like to ask, just a reminder that there are two ways you can do that. So you can type your question into the question box and we'll see those come through and we'll read them out for Karen and Deb to answer you. Or you can press the button that looks like a hand and we'll see that hand come up and we can unmute you if you have access to a microphone. So Karen and Deb, I might put the first question to you. So this one's from Stephanie. Can an independent person charge a fee, or is the independent person a voluntary position?
Yep, Stephanie, it is a voluntary position, so they can't charge a fee. There's also there's no payment to them from any source, and that was the intention of that was to ensure that they're just there to support the families. Having said that, there will be some brokerage money available to assist with out-of-pocket expenses, travel, whatever else. So there will be some funding available, but it's not a paid position. It's a voluntary position to support.
Okay, great.
Yeah.
So the next question, again from Stephanie, is do carers with a child on a permanent care order still receive a fostering allowance?
So it's Deb here. They won't be receiving a fostering allowance, but what they will be receiving, they are able to receive financial assistance. It's not a foster care allowance because they're no longer a carer. They are actually the permanent guardian, but that's a case-by-case basis around what that financial assistance would look like.
Okay. Any other questions out there in the audience? Now is your chance while we've got our experts on the line. So I'll just give you a moment to type those questions in. So it doesn't look like we've got any other questions coming in. So we might start wrapping up. If you do have a question, finish typing that one in now and we'll be able to read them out for you during the presentation. Otherwise, you can send your questions through to the email on the screen there, which is the CPA reform at csy.qld.gov.au. So thank you very much, Deb and Karen, for joining us today and presenting on these reforms. Some really important reforms coming in, and it will be really interesting to see how they play out once we hit the end of October. Thank you again, and make sure you do fill out the feedback form once it's emailed out with the link to the recording for today's session, and we'll see you next time. Thanks, everyone.
Thanks, everyone. Thanks, Debbie. Oh, thanks, Carly.
Thanks so much. See you next time.